Assalamu alaikum, good evening. Welcome to another edition of Legal Ease, where we convert legal jargon into legal ease for you. This evening we're going to be talking about labor brokers, about temporary employees. I've got a guest who's a senior commissioner at the CCMA from the Pretoria office. He's been with the CCMA for over 10 years. My guest this evening is Commissioner Mduduzi Khumalo. Commissioner Khumalo, thank you for making yourself available and thank you for coming here. For a start, just tell us a bit about yourself so that the viewers know who we're dealing with, a bit about your experience, a bit about your background, and then we'll talk about the labor brokers.
Thank you, Prof, and good evening to you and good evening to the viewers. I'm happy to be here, even if it's this late in the evening. My name is Mduduzi Khumalo. I have been with the CCMA, as I've already said, for 10 years. It's a long time in this field. And as a CCMA commissioner, I've done dispute resolution, I've done dispute management and prevention before I moved to Pretoria as an acting senior commissioner. I've been there for almost a year now, and I'm enjoying it.
Right.
Yes.
The labor brokers, particularly viewers, we're going to be talking about labor brokers, but you can, when it's time to phone in, you can call in and ask anything that the CCMA deals with, and the commissioner will be happy to answer your questions. But labor broking and specialist service, and not all commissioners do that, only some of you are qualified to do that. But let's kick off by talking about, tell us, what is non-standard employment, what are labor brokers, what are temporary, because we know, for example, sometimes people have cleaning services.
Yes.
Where do they fit into? So just a bit of background about this.
You're right, Prof. Actually, there are specialists to deal with this dispute. What CCMA has done is to create specialists in each and every category of these new amendments so that the public out there can get the full benefit. These commissioners are trained and they are assessed and evaluated, and once they pass their evaluation, they are also monitored and given the support, and they are very qualified, and I'm sure you can see the awards that come out of those commissioners. The labor broker has been an issue for a very long time in our labor market. You know, labor formation has been demanding that they be banned, and the government had to play a balancing act to try and make sure that while we don't totally ban them, because we may need them as a country because of the economic climate that we operate in. So the government came up with the legislation to protect those employees who are employed by labor brokers. So if you are a non-standard employee, you are an employee who's employed on a temporary basis or by a temporary employment service provider, or you are on a fixed-term contract. So those are the three categories of employees. When we talk about non-standard employment, we're talking about those three categories of employees. And cleaners who are employed by cleaning companies, private security companies, are not labor brokers.
Okay.
Yes, they are not. They are actually service providers, because the cleaning company provides service to a business, and the security company provides security service to a business. So whereas non-standard employment, that is employees who are preferred through a labor broker, are employees who are employed by the labor broker itself and are sent to the client for either a temporary assignment, and they are there for maybe a short period, and after the completion of that assignment, they are expected to go back to their employer, who will then find them alternative work. But what has been happening in the past is that you will find that the labor brokers will and the employers will keep these employees for longer period. So the unions were complaining that these are taking permanent positions. So the legislature, in order to try and cap that anomaly, came up with the legislation which we are talking about today, Section 198, capital A, which specifically seeks to arrest that situation. So if you are assigned to a client of the labor broker for a period less than 3 months, you are regarded as an employee of the labor broker. But if that period exceeds 3 months, then the deeming provisions comes in. You are deemed to be the employee of the client for the purposes of the Labor Relations Act.
Okay, but that I suppose also is not cast in stone. It could be that there's a project that lasts for more than 3 months. In that case, I presume you would still be an employee of the labor broker. Or is the 3 months cast in stone?
It's not. You are right, Prof. If you are there for an assignment, for instance, a permanent employee is gone on sabbatical leave or maternity leave, and the employer enlists services of an employee from a labor broker, then it is clear when you are engaged that you are there for that period when the person will be away. Therefore, the period can exceed 3 months in that instance.
Because it's for a specific purpose, it's to fill the post of somebody who is a permanent employee. So
Correct.
Obviously that employee can't be replaced because that employee is going to
Will come back at some point.
Okay,
That's correct.
And how does the commissioner at the CCMA determine who the employer is? Because that could be a bit of a problem. Because labor broker sends the employee there, employee works there for 2 months, let's say less than the 3 months. We can look at both scenarios. 2 months, and suddenly that person is dismissed by the labor broker, obviously, because where he is assigned, that person can't dismiss. The employee now needs to refer the matter to the CCMA. Who does the employee say is the employer in that case?
If the employee has worked for a period less than 3 months,
Right.
that employee still belongs to the labor broker
Okay.
for the purposes of the Labor Relations Act and the contract of employment. However, if the employer terminates that employee because the employer is trying to avoid the application of the Section 198, capital A, then that employee can claim a dismissal still against the employer, the labor broker.
The labor broker.
Yes.
And the contract then is between the company where the person is placed and the labor broker.
The contract of employment is between the labor broker and the employee. Yes.
And the labor broker has got a contract with the employer where the person
As a
is
service level agreement with the client. Yes.
Okay, and just a bit more about these categories of employees, because I know this can get a bit complicated.
Yes,
You mentioned it, but maybe
we dealt with the labor broker. The next is the fixed term contract employees. Fixed term contract employees are employees employed on a fixed term contract for a limited duration. It must be very clear from the start that you are employed for this period. And if that period exceeds 3 months, then that employee has a right to claim either permanent employment against the employer. The employer has a recourse to show that that there is justifiable reason why the term is fixed for longer than 3 months.
Okay, and sometimes there is, because sometimes the employer has got a certain project that the employer is to do, and that may be more than 3 months, so that would be a justifiable.
Yes, one of them is a project where the employer will say you are employed to work in this project, and the project is for a definite period, and at the end of that period, your employment will terminate.
Okay, and what does the law say about non-standard employment? Because there is something like that.
The law say for you to qualify for this protection that we are talking about, you must be earning below the threshold, number one. That is 205,433 rand 30 cents per annum.
Right.
So if you earn above the threshold, you don't enjoy the protection of this section of the Act.
Okay, and how would the CCMA or the commissioner determine who is the employer sometimes and who is the employee? Like you said, if it goes beyond 3 months, then maybe the labor broker is not the employee anymore. Maybe the place where the person is placed is the employer.
The
How
labor
would the
broker,
commissioner then decide?
the labor broker, in terms of the contract,
Yeah.
remains part of that employee's employment life in that employment space. For the purposes of the Labor Relations Act, after 3 months, the client of the labor broker is deemed to be the employer of that employee for the purposes of the Labor Relations
Right.
Act. Yes.
Unless the client can show there was a specific reason for that. Who has to show that? The labor broker or the client?
If the employee raise a dispute with the CCMA against either the employer or the client, both will be then required to attend the CCMA to go and prove that, no, I am not the employer. This person was employed to come in and fill a space for a person who's gone on sabbatical leave. This was advised to the employee at the commencement of the contract or when he commenced employment, and there's the proof. Then the onus shift back to the employee.
Okay, that's an
Yes.
important point. So if the
Yes.
employee is dismissed, the employee is sometimes not sure who the employer is. The employee will then cite the client as well as the labor broker.
As the labor broker.
And then at the CCMA, the commissioner will determine who the employer is.
The commissioner will determine as to who's the correct employer and the reason for the termination.
We've got a caller on the line. Assalamu alaikum, good evening.
Good evening, sir. I've got a question here for the commissioner.
Please go ahead.
Good evening, sir.
Okay. Good evening, gentlemen and commissioner. My question is on the Brassi judgment. And in that judgment, there was a reference made to the difference between the TESS employees, that's your temporary employment services, versus your labor brokers employees, and at which point the issue of deemed becomes applicable. Could you just give me an idea of that? I'll listen on the TV. Thank you.
Thank you for the question, sir. I think Brassi made a very interesting comment on that issue. Brassi said, if the person is assigned to a labor broker and that person works at the labor broker for a period exceeding 3 months, at the client, and works for a period exceeding 3 months, that person has a dual employment relationship with the client for the purposes of the Labor Relations Act. Hence my emphasis all along. And for the purposes of the contract, it is with the client, the labor broker.
Okay.
So though the two become employers for different reasons, one for the contract and the other one for purposes of the Labor Relations Act. And I just need to clarify one other thing with the caller, that TES is a temporary employment service and is what we traditionally refer to as a labor broker.
Okay.
It's the same thing, yes.
Okay, let's hope the viewers' questions answered. And since we've had one call already, we'll open the line so other people can call in as well. The number will be on the screen, but for now we'll take a short break. After the break, please stay tuned. We will take calls after the break. Assalamu alaikum, good evening again. Welcome back to Legal Ease, and our guest this evening, Commissioner Khumalo, who's with us. He's been talking about labor brokers, temporary employment and fixed-term contracts, and we're going to continue. Commissioner Khumalo, under what conditions, I know we've touched on it, under what conditions is temporary employment service allowed?
You see, as I said, the current economic climate that we operate under, it's actually very difficult for employers. At times it's difficult to keep an employee permanent, or at times you have a small contract where you have to hire 2-3 people to do a quick job, and now you cannot employ that person permanent. So on those conditions, you are allowed to employ a person on a fixed term contract or get an employee from a temporary employment service provider. But the law is providing protection that you must not abuse that system, because it was abused in the past. So the law is trying to close that gap to say if the person is there for longer than 3 months, you must be able to justify. And if you cannot justify, then that person will be deemed to be your employee as the client of the labor broker or the temporary employment services.
Okay, because a lot of employers used labor brokers, they used temporary employment to in fact contract out of the Labor Relations Act, because
True.
then they didn't have to comply with the Labor Relations Act, they didn't have to provide all the benefits that other employees are getting. And if the person was dismissed, they said, well, it's not our employee.
It's not our employee,
You know,
it's the employee.
Deal with the labor broker.
Yes. And that's why the law says employers are encouraged to come and bring justifiable reasons. The law provides a non-exhaustive list of reasons that employer can provide for either fixing the term of the employee for longer than 3 months. One of those reasons is replacing an employee, obviously, who's temporarily absent, either due to ill health, or is on maternity leave, or on sabbatical leave, or temporary increase in the work, where the employer experience maybe new orders coming in and they need to be attended to urgently, so the employer can bring in new people to assist with that, or where you need to employ students for experience purposes. You bring them in maybe for a period of 2 years or whatever period that you believe they will need to acquire that experience. And also the issue of a specific project, as I said, because most of the time you find a small project that requires you to deal with it quickly and you need more hands to do that. And sometimes you employ people with a work permit. So if you employ a person with work permit, obviously the employment is dictated to by the work permit. If the work permit is 24 months, you can't exceed that period. So those are the times where employers will obviously have to engage people on short term.
And where does seasonal workers,
they also
fit into?
They also fit into that.
Yeah.
And that's why I say if you increase, if you experience an increase in work, you can then call in few people. That's why you'll find companies have a pool of people that they can call in anytime when they have they experience increase in work or seasonal work in your farming sector, agriculture, and so forth.
Yeah, because in the farming they need people at a certain time when they need to come and pick the fruit or pick the vegetables.
True.
So they would employ them just for that particular
period. And once that period has passed, then they have to release
And
them.
Things like, so you know, soft drinks, maybe in summer they sell more. Could they use it in that space as well?
And when you sell ice cream, you know, peak season, it's the festive season, everybody has got money, they want to spend money, and it's hot, they want to buy ice cream, so you need extra hands for you to run your business.
Viewers, you're welcome to call in if you have any questions that you want to ask Commissioner Khumalo. The phone number is on the screen. It's 011-086-7777. You can phone in and ask anything about labor brokers, about temporary employment services, dispute resolution related to this, or if you want to talk about any other dispute at the CCMA, you're welcome to call in. Let's talk about employer has temporary employees through a labor broker, and maybe the contract is for a fixed period, but suddenly the employer needs to retrench. Is that going to be a problem for the employer?
In most instances, it is not a problem for the employer. Because if the employer needs to retrench, first the employer needs to see if he still requires the services of the employees that are provided by the temporary employment service. And if he does not, he can remove them and check if he still have to retrench. And if the need still exists, then the employer can retrench, looking at its permanent employees. Yes.
And if the employer did retrench, the employee can refer that matter to the CCMA.
You mean the permanent employee?
Either employee can, if they believe that the retrenchment is unfair, whether it's permanent, whether it's temporary.
Of course.
And if it's a permanent employee, obviously it is, the employer is clear.
Yes.
If it's from the labor broker,
Yes.
again, does he cite both the labor broker and the client, or?
as I said, it depends. If the employee has been with the client for more than 3 months, then that employee can cite both the employer and the client. But if the employee has been there for less than 3 months, that employee is still an employee of the labor broker. And therefore, if he has a dispute, it is against the labor broker. Unless the employee suspects that the termination is for reasons that is to avoid the application of the deeming provision. Yes.
We sometimes get stories, we hear stories about employers using fixed-term contracts or using labor brokers in place of probation. What happens in a case like what rights do employees have in a case like that? What would the employee have to do? Who has to prove what at the CCMA?
If, as I said, if the employee is employed for more than 3 months and is from a labor broker, that employee is deemed to be an employee of the client of the labor broker. And if the employee is on a fixed term and the period has exceeded 3 months and the employer decides to terminate and the employee believes that the termination is to avoid application of the law, that employee can refer the dispute to the CCMA, and the employer will be required to prove that there is a legitimate reason to either extend the fixed term or to terminate the service at that time.
Okay, but it's clear they can't use fixed term instead of probation.
No, they cannot use fixed term.
Okay. Tell us a bit about probation. How would probation work, just so that employers out there would know and employees would know in terms of probation, what their rights are? How do you put people on probation?
It's a very interesting issue, Prof, because one of the issues that our law does not determine the length of probation. Our law says parties can enter into a reasonable probational period. So if you are employing, say, maybe a sweeper, you know that this person, you want just to see his competency and his fit into the business, then that person, 3 months would be a reasonable period. But if you are employing a CEO, you may need 12 months probation. And after 12 months, if you are still not satisfied, you can't just extend the period. You must first evaluate the person throughout the probational period to see and to advise the person that these are the areas that you need to improve on. How do we assist you to improve in these areas? Give the person the necessary support to improve in those areas. And if the person does not improve, only then at the end of the probational period you can then decide to terminate after obviously a meeting.
Okay, so it's clear probation is not fixed. It depends on the nature of the job. It depends on the complications of the job. It depends on, also I would assume it depends on the person that you're employing, the training that that person has, the experience that that person has.
And the fit into the business culture, it's also important, because when you evaluate everything, competence of the person, how does it fit into the business culture and all that.
And you're saying during that period that the person is on probation, the employer can't just leave the person there and at the end of the probation period say, okay, your probation is over, you're not good enough, you're fired.
Of course, the employer must at all times speak to the person and advise the person if there are areas of improvement and ask the person if he needs assistance, training, coaching, any type of assistance that the person may require. The employer must provide, so that at the end of the period, and if the person is not successful, the employer can then say, we have done our best to assist you to fit into the business, to also perform at your best, but no, we don't think you are a fit to the business.
Okay, so counseling, training during the probation period is
very
required.
important, very important.
Right. And I presume if it's somebody who's highly experienced, highly trained, then training is not a requirement, but
not
counseling obviously is a requirement.
Yes, it may be a requirement. And also coaching sometimes, because I may come with my experience from CCMA and I come into your business and you do things differently, so you need to coach me through those processes.
And the training could be on-the-job training. It doesn't have to be sort of sent off to some college or something.
Not necessarily, yes.
Okay.
Yes.
And then if the employer wants to dismiss, do the same dismissal rules apply, or can the employer just say, well, you're dismissed because you're not meeting the requirements?
That's why I was saying from the start, there must be meetings between you and the employer for an update of how you are performing, and so that you also need to raise issues where you feel that you need help. And at the end, if you have not met the required performance standard, the employer can then call you to a performance meeting and say, no, you are not meeting the standard. The rules, the procedures are not as stringent as when you are dismissing your permanent employee, but there must be a performance meeting.
Okay.
Yes.
But we'll continue that, because I presume this procedural and substantive fairness
True.
is still a requirement, but it's time for an ad break.
Okay.
We'll take the break, and then viewers, after the break, we'll be back with Commissioner Khumalo. And again, if you have any questions at that time, please stay tuned and you can call in with your questions or comments. Assalamu alaikum, good evening, welcome back. And we've got a caller on the line. Hello, assalamu alaikum. Hello, assalamu alaikum.
Hi, Prof.
Hi, please go ahead with
Hi,
your
Prof.
question.
Yeah, Prof. Thanks. It's for you, Commissioner.
Yeah.
Hi.
The same question again. Similar question. I've got where you have a CEO might have a dispute. I know there is certain section of the Act, the LRA in particular, that prevents a person, if earning a certain threshold, to bring a matter to the CCMA. Or is it all matters of dispute that will come to the CCMA? And then arbitration later, or does it go conciliation and then refer it to labor court? That's the first question. The second one is that if you have large scale and small scale retrenchments, what will happen in this case where you have dual employment, as the question was raised, where the person is deemed to be a dual employment with the broker versus the actual client? What would happen in the case when they are actually retrenched? Thank you. I'll go over the TV. Thank you.
Okay, let's start with the first one. Senior employee,
Very interesting
does it make a
question.
difference? Still an employee?
It's still an employee. Yeah. The law covers that person like a person who earns 1,500, even if he earns R1 million a month. There was a discussion around that. He is right, but it did not get into the amendments. Yeah. There was a discussion that perhaps we can charge those employees, but I think the legislature was discouraged because the constitution of the country states that everyone has equal rights.
So it doesn't matter the level, the person is still an employee. It doesn't matter whether he's dismissed for misconduct, whether he's dismissed for incapacity, whether it's a retrenchment. That person goes through the same procedure. Conciliation at the CCMA, and we're going to talk about retrenchment, large scale and small scale, because that's the second part of the question. Yes. Small scale, then it's arbitration. If it's a large organization, obviously labor court. Can you tell us a bit about how the retrenchment works? Because that's the question that was asked.
What was important about that question, Prof, is that the caller said, what happens to those employees who are now deemed to be the employees of the client during the retrenchment process? They form part of the employees of the client, and therefore they will be affected like anybody else in terms of the process of retrenchment. They should be invited to the retrenchment as per Section 189, subsection 3 of the Labor Relations Act, and they should participate, and the employer can, after the consultation process, decide who get retrenched. But they are affected like the normal employees of the employer because they are deemed to be the employees of the employer.
Okay, just to clarify for some viewers, we've had this discussion before on the programming. When an employer needs to retrench, the employer must consult, firstly, if there's a workplace forum, with the workplace forum and the registered union. If there isn't a workplace forum, must consult with the registered union. If there isn't a registered union, must consult with the employees, and that's what the Commissioner is talking about, that the employees that are going to be retrenched must be part of that consultation process.
Yes.
And the process is the same. But tell us a bit, because part of the question was, you know, if it's a large company, small company, is the retrenchment process, dispute different? When does the person go to arbitration, for example? When does the person go to the labor court?
In terms of the Act, if the company employs less than 10 employees and retrenches maybe 5 or so of those employees can elect to go to arbitration. But if it's a large-scale retrenchment and the employer retrenches more than 1 employee, those employees must, after conciliation, must take their dispute to the labor court for adjudication.
Okay, so a single employee can choose.
A single employee in terms of Section 191, subsection 13, can choose to take the dispute to arbitration.
And usually that's what the employee will choose, because the employee won't want to go to the...
They won't have the financial muscle to take the matter to the labor court. So they will choose the arbitration. And also, sometimes the labor court process takes time. Our processes as a CCMA takes 90 days. We're in the arbitration process.
Right.
Yes.
And of course, if you go to the labor court, you're probably going to need a lawyer, because, you know, the layman won't know what to do at the labor court.
True. But even the labor court lately, they assist the employees.
Yeah, right.
When they go there, there are performers that they can assist to complete. However, the rules of the court becomes a challenge for the employee. It's unlike the CCMA. It's more user-friendly, where we can also, the commissioner is expected to assist the employee even in the arbitration to get to the bottom of the dispute and understand what is the issues in dispute, so that when the commissioner makes that award, he decides the main dispute.
Okay, one of the things we need to talk about, obviously, is temporary employees.
Yes.
I mean, we discussed, but I mean, temporary employees is a special category.
It is.
Different to others. Can you talk to us a bit about
temporary employees? In terms of Section 198C, it does not apply to employees who are above the threshold. So if you earn above 205,433,030, you are not covered in terms of Section 198C, and therefore your dispute will be, or if you have a dispute with an employer, you cannot cite Section C. And it also does not cover employees who work less than 24 hours in a month. As you know, also the UI Act does not cover those.
Right, they don't have to be registered for UIF.
Of course.
But if they work for more than 24 hours a month, then they have to be registered.
They have to be registered for UIF. Irrespective of their citizen, they have to be registered. And also, during the first 3 months of continuous employment, they are not covered by Section 198, capital C, because at that time they are still working what we would refer to as probational period, to see if the employer would really require them further. So once they pass 3 months, then they are covered by the Act. The employer who employs less than 10 employees is also not covered by this section of the Act. Or if the employer employs less than 50 and has been in business for less than 2 years, that employer is also not expected to comply with this section of the Act. So the legislature was trying, Prof, his best to make sure that encourages people to create employment so that we can employ many people. You can see the balancing act was very difficult here, but you can see that there was an attempt. So not everybody is covered, but immediately after 3 months, these employees are covered by Section C, which states that they should not be treated differently from permanent employee, and they must have access to job opportunities within the business. If there are trainings that are provided in the business, they must have access to those trainings. So Section C seeks to protect those employees that you will find normally in one of these retail stores. They work in Friday, Saturday, Sunday. So the Act was trying to play that balancing act to ensure that they get protection also.
Okay, so some of these temps that we're talking about obviously could be temps for a very long time because, like you say, supermarket, cashier works only on a Saturday or only on a Sunday or Saturdays and Sundays or public holidays because the permanent employees, need time off, so they get time off, they hire temporary. But they could go on and on being temporary employees.
So that's why the protection, the legislator says, if they've been here for more than 3 months, that means these people are important. So we need to protect their interests to make sure that they also have access to job opportunities, training that is offered in the business, and that they are not treated less favorable than your normal employees.
Okay, but I presume some people would prefer to only work on those weekends. Students, for example, at university, they may want to work only on a Saturday or only on a Sunday. So would the same thing apply to them?
As long as they work, they earn below the threshold, Prof, and they work more than 24 hours in a month, the Act gives them protection.
Okay, so the law says they must get the same treatment as everybody else.
Yes.
I presume it affects their salaries as well.
It does, it does. Yes, in terms of salaries, they must not be treated less favorable than a comparative employee of the business.
And that's where sort of equal work for equal pay comes in.
That's where it comes in, Prof, yes. That's where the employers struggle with it. And even the employees. I've actually seen a lot of unions struggling to actually try to articulate exactly what is equal pay for work of equal value. Because I don't know, maybe they assume that it is just on the basis of the salary only. It is not. It takes more than that. You need to come in and tell us why you believe that even though this person is not earning the same, it's a discrimination issue.
Okay, so there must be a valid reason if somebody is not earning the same.
Yes.
But it could happen. It could be based on, could it be based on years of service or?
Seniority, years of service, merit, quality, quantity, all those things are there. But the employee must first establish the ground. What is the ground is challenging the unequal treatment on, and then the onus shift to the employer, depending if he's challenging it in terms of section 6, subsection 1 of the Employment Equity Act, or on arbitrary grounds, subsection 2. And if it is subsection 2, then the employee must show, then the employer must show that it is not actually discriminatory and so forth.
Okay, and one of the things you said is they must have the same benefits, sort of the same treatment that other people. If permanent employees, for example, are getting specific training, which would help them in their careers, these temporary employees, are they entitled to get that training as well?
Yes, it must be extended to them. Once they've worked for more than 3 months and they earn less than the threshold, it must be extended to them.
Okay, now this could be very interesting because you can get a temporary employee.
Yes.
Let's use the example of a student because they don't want the permanent job because they're studying.
True.
And the only time they're free is on the weekend. Saturday, Sunday, they want to work.
They went to work.
But now that employment goes on for more than 3 months. Now what happens? Because they still only want to work on a Saturday and a Sunday.
You see
Does it make a difference?
You see what the legislature has done, Prof. The legislature has said, extend it to them whether they want it or they don't want it. It is their choice.
So they can then decide.
Yes, don't discriminate.
Okay, so that's interesting.
Yes.
And if they are dismissed, they have the same rights as everybody else, or if they're treated unfairly, they can sort of take an unfair labor practice case to the CCMA, or if they're unfairly discriminated against, they can follow the route as well.
All the protection of the law extends to them as well.
And you've said earlier that if it's less than 24 hours a month, they don't have to be registered.
No, they don't have to, no.
The minute it's more than 24 hours, they have to be registered.
Yes, there's an obligation on them.
Okay. Appropriate time for us viewers to take a break. We'll take a short ad break. Stay with us. Stay tuned after the break. Again, if you have any questions, any comments, Commissioner Khumalo is here to answer your questions. Assalamu alaikum, welcome back. We've got Commissioner Khumalo telling us about temporary employment employees and about labor brokers and dispute resolution. But we've got a caller on the line. Caller, go ahead.
Yes, Prof. Could you ask the Commissioner to explain people that are receiving stipends as learnerships? Are they deemed to be employees? And are they afforded the same protection? I'll listen again.
Okay. Some tricky questions.
Some tricky questions indeed. Learnership are employed in terms of the Skills Development Act. And it's provided there. If there's a dispute about any issues pertaining to learnerships, Department of Labor has jurisdiction to address those disputes. They are not in terms of the Labor Relations Act.
Okay, so they won't be covered. So if they have dismissed, they need to go to approach the Department of Labor.
Yes, in terms of...
the Department of Labor will deal with those cases.
Yes, in terms of Skills Development Act.
Okay.
Yes.
And then let's go back to, we were just before the break, the previous break, we were going to talk about procedural and substantive fairness for probation employees. We didn't talk about that because we had a caller. So can you tell us, procedural fairness still applies for people who are on probation?
It does, Prof. It applies to all employees. Right. The right to be heard, it's a constitutional right. So everybody has a right to be heard. Before an employer takes a decision to terminate your service, the employer must give you an opportunity to make representation. So even if you are employed as a professional employee, before the employer terminates your service, the employer needs to sit around the table with you and say, this is what we have done as the company to assist you to improve your performance, and to date you have not improved. Tell us why we should not terminate.
Right. And that's not the same as the performance hearing.
It is.
It's the same as the performance
hearing. It's a performance hearing
right.
for a probation employee.
For a probation.
Yes.
Right.
It's slightly different for a permanent employee. Right. Because a permanent employee may be encountering different challenges in his life, so as an employer you need to approach it differently. But where you have a person on probation, obviously the purpose of probation is to test the competency of the individual, and you have done so for a certain period and you have come to a conclusion that the person is not meeting the required standard.
Okay.
Therefore you sit around the table and said, this is the support we have given you for the past 6 months or so, and we have also extended your probation period, but you have not come to the party. Tell us why we should not terminate you. Right. Then that person gets an opportunity to make representation as to why he should not be terminated. But he must also be afforded the rights that are afforded to permanent employee, right to be represented by a trade union representative of his choice, and to, as I said, to make representation, to have an interpreter if he so wishes, and all that, the rights that are extended to permanent employees in that performance meeting.
Okay, so it'll be treated the same as anybody else who's poor performance,
yes.
But it is easier. But in the case of misconduct, that would be the same, irrespective of whether it's probation or not.
In the case of misconduct, that is the same, irrespective of whether the person is on probation or not. So the rights that are extended to permanent employees are extended to probationary employees during the misconduct hearing. Yes.
Okay, one of the things I was going to ask you to, but I think we're going to run out of time because we've probably only got about half a minute left, is, dispute interpretation of the section that deals with temporary employees. I don't suppose you can squeeze that into half a minute.
I can, Prof. Dispute relating to the section that we've been talking about, the non-standard employment, is in terms of section 198, capital D, where if the employer and the employee and the temporary employment service provider and the client don't agree, the employee has 6 months to refer the dispute to the CCMA for interpretation and application. But if it is for dismissal, Prof, and unfair labor practice, the same time frames that apply to those disputes will apply in this case.
Which is the 30 days and the 90 days.
Yes, Prof.
Okay.
Yes. I'm sure I've squeezed it in, yes, perfectly.
And I can say thank you very much for making yourself available, for coming here. We've learned quite a lot about labor brokers and temporary workers. Your viewers, thank you for being with us. And inshallah, we'll be back next week. And Ashraf will be with us next week to talk about the law to make legal jargon into legal ease for us. Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you very much.
Thank you, Prof.
Right.
Thank you.